distinguish between decree and judgment. The terms decree and judgment are closely related but not identical. A judgment forms the basis of a decree. The provisions relating to them are contained in section 2(9) and section 2(2) of the Code of Civil Procedure 1908 CPC respectively. According to section 2(9) of the CPC, a judgment means the statement given by the judge on the grounds of a decree or order. It contains the facts of the case, the issues involved, the evidence produced by the parties, the findings of the court, and the reasons for arriving at a particular conclusion. On the other hand, according to section 2(2) of the CPC 1908, a decree is the formal expression of an adjudication which conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. A judgment is therefore the reasoning process of the court, whereas a decree is the formal and operative part of the decision. In a judgment, the judge explains why a particular decision has been reached, while the decree formally records what the decision is. It is necessary for a judgment to contain the grounds and reasons for the decision. However, a decree does not contain details reasons. It merely expresses the final determination of the rights of the parties. Similarly, while a decree must be formally drawn up, a judgment need not contain a formal expression of the order, though it is desirable that it should do so. A judgment always precedes a decree. After the court pronounces the judgment, a decree is prepared in accordance with the findings recorded therein. Thus, a judgment represents a stage period to the passing of a decree or order. Further, Order 20, Rule 6A of the CPC 1908 provides that the last paragraph of the judgment should clearly state the precise relief granted by the court. This facilitates the preparation of the decree. In terms of legal effect, a decree is executable and may be appealed against according to law, whereas a judgment by itself is not executable. The rights of the parties are enforced through the decree that follows the judgment. Conclusion. Thus, a judgment under Section 2(9) of the CPC 1908 is the statement of reasons and grounds given by the judge for arriving at a decision, whereas a decree under Section 2(2) of the Code of Civil Procedure 1908 is the formal expression of that decision. A judgment explains the basis of the decision, while a decree gives legal effect to it. Therefore, every decree is based on a judgment, and a judgment necessarily precedes a decree.